So we'll start in a couple of minutes. Mm. Okay, so I'll begin, and I'm going to discuss Shireen Razak's article in detail. And Razak's article is about Cindy Gladue and the murder of Cindy Gladue. And Cindy Gladue, unfortunately, died in Edmonton, and Cindy Gladue was a mother of 3 children, and she was 36, and she was found dead in an Edmonton hotel room. And so on March 18th, 2015, a jury found Bradley Barton not guilty of first-degree murder. In June 2017, the Alberta Court of Appeal has overturned Barton's acquittal and ordered a new trial. The appeal court decision said there were flaws in the way the jury was instructed to consider sexual assault offenses and the laws relating to consent. Barton's lawyer appealed, saying the appeal court's ruling is flawed. In March 2018, it was announced that Supreme Court will review the order for a new trial. So Barton has now gone through a system of appeals, and the case really struck a nerve for the feminist movement. And there were mass protests throughout Canada in support of Cindy Gladue's family. During the trial, Cindy Gladue was referred to as a native prostitute or an Indigenous prostitute over, I think, 50 times, 15, I should check, a number of times. And so there were, I think, 15. There were many, many times. The press sometimes says 24, more than 24 times is what the CBC has reported. Cindy Gladue, age 36, found dead in a bathtub of a West End hotel in Edmonton, was referred to more than 24 times before a jury as a native prostitute. Bradley Barton, who's accused of murdering Cindy Gladue, was never referred to as a white man. And so from a philosophical, people get kind of anxious about these terms like white man, or, I mean, the question is why? Like, what from a philosophical or intellectual or even linguistic perspective does this do? So if I am a lawyer and I name Cindy Gladue as a native prostitute over 24 times, but I do not name Bradley Barton as a white man, what does this mean? And I think these categories really make people anxious because of criminal justice. So in a different time, calling, say, one of Canada's founding fathers a white man or a Englishman or Frenchman wouldn't have been offensive, but we now have modern laws. And so to say that Bradley Barton is a white man is really accusatory. However, what lawyers did was to call Cindy Gladue a quote native prostitute over 24 times. What they're essentially doing is putting Cindy Gladue on trial after she's dead. So being a sex worker is against the law. So Cindy Gladue is found dead in a bathtub in Edmonton in a hotel. This is really sad. But to call her a native sex worker, a prostitute, even the word prostitute is quite an old word, like native and prostitute. Indigenous and sex worker tend to be the most progressive and least insulting terms to use for people who are engaged in sex work and Indigenous. But what is essentially being done is to accuse Cindy Gladue of crimes after she's dead. So this is similar to George Floyd. So George Floyd has been referred to as somebody who had a counterfeit $20 bill over and over again. And so in the trial of Derek Chauvin, who was accused of murdering George Floyd has a counterfeit $20 bill. George Floyd no longer has any money, counterfeit or not, because George is dead. So you can put someone on trial after you kill them and thereby make it legal to kill them. And so this is done often when any group of people who are deemed to be minorities in this time period are murdered. These people are put on trial, and what is essentially being said is that it is okay to kill these people because they were criminals. And so it allows the public to then pretend they are the police or pretend they are vigilantes. And like some of the most terrifying have been like off-duty security guards like George Zimmerman, who killed a 15-year-old boy named Trayvon Martin. Like you're essentially allowing the public to just, I guess, to decide that someone is a criminal with counterfeit money or a sex worker, and then they can kill. So the Cindy Gladue case then received lots of attention from the feminist movement in Canada and throughout the Americas. And there were many protests against this kind of vilification of Cindy Gladue and against the exoneration of Bradley Barton, who was consistently defended irrespective of the kind of brutal violence. Like Bradley Barton committed really, really horrific acts against Cindy Gladue's actual body. So this case is one of many cases that corresponds with the inquiry into missing and murdered Indigenous women and girls, which led to the MMIWG report, the Missing and Murdered Indigenous Women and Girls report. So there are 1,181 missing and murdered Indigenous women and girls in Turtle Island of Canada. The inquiry granted official standing to approximately 100 parties, including persons or groups who demonstrated they had a substantial and direct interest in missing and murdered Indigenous women and girls, as well as others with expertise and perspectives deemed essential for the inquiry to fulfill its mandate. Despite the fact that the homicide rate of non-Indigenous women in Canada is declining, a 2014 report from the RCMP found that the homicide rate for Indigenous women remains static. The same report identified a total of 1,181 missing and murdered Indigenous women and girls in Canada. So the Missing and Murdered Indigenous Women and Girls report in Canada documents the ways that institutional discrimination works against Indigenous women and girls. The important point about the report is that it is not about individual like or dislike. When we think about discrimination, racial discrimination, gender-based discrimination, I mean, there are all of these very personal sentiments like beauty or niceness or likability that come to mind. But institutional discrimination is not about like or dislike. It isn't about it isn't about whether or not someone favors someone else. Institutions such as the RCMP, the Royal Canadian Mounted Police, the Canadian healthcare system, the system of courts, lawyers and judges often all participate in forms of erasure of Indigenous women and girls as people. Terms like native prostitute already criminalize people and make it possible for Indigenous people to become very precarious. So if one is always accused of crime or being accused of crime, then can they ever be a victim of a crime? And from a feminist perspective, if women are always seen as kind of flawed people, could they ever be subject to domestic violence? Yes, the answer is yes, someone could be subject to domestic violence. Like the construction of personhood has always allowed the most privileged people to violate the rights of those who are not persons. And so this kind of refusal to acknowledge personhood is seen over and over again in cases like the murder of Cindy Gladue. So I'll discuss 5 points: intersectionality in the law. Then I'll discuss colonial violence and racialized women. Then I'll talk about legal gray zones, a space for justice. And this is one of Dr. Shrun Razak's most interesting points in the article is this idea of a legal gray zone. A gray zone that exists where people do not have legal rights or legal rights can be suspended. And Cindy Gladue's case is really about certain areas in Canada, like Edmonton, which is similar to what Razak wrote earlier in an earlier time period about the downtown Lower East Side in Vancouver. And finally, I'll discuss judicial reviews and I'll discuss LEAF, which is a organization and the acronym is it's the Women's Legal Education Action Fund, which advocates for gender equality in law. So firstly, intersectionality. I previously discussed intersectionality and the writings of Kimberly Crenshaw. And I guess the question is, can we use intersectionality and these concepts from Black feminism to discuss cases of missing and murdered Indigenous women and girls? And I argue that we can. And this is a clip of Kimberly Crenshaw Williams, again, discussing intersectionality, which is a key concept that I hope that you find enjoyable or take away from this course.
Intersectionality is just a metaphor for understanding the ways that multiple forms of inequality or disadvantage sometimes compound themselves. And they create obstacles that often are not understood within conventional ways of thinking about anti-racism or feminism or whatever social justice advocacy structures we have. Intersectionality isn't so much a grand theory, it's a prism for understanding certain kinds of problems. African American girls are 6 times more likely to be suspended than white girls. That's probably a race and a gender problem. It's not just a race problem, it's not just a gender problem. So I encourage people to think about how the convergence of race stereotypes or gender stereotypes might might actually play out in the classroom, between teachers and students, between students and other students, between students and administrators, and commit themselves to understanding that as a way of intervening and providing equal educational opportunity for all students, regardless of their identity. Identity isn't simply a self-contained unit. It is a relationship between people in history, communities, people, and institutions. So schools do a good job when they understand that and when they commit themselves to curricular development, to opportunities in the school for all students to understand the histories that have brought us to this particular moment. You can't change outcomes without understanding how they come about. So independent schools can take the lead on that to be responsive to their student populations and to the communities out of which the students come.
So Kimberly Williams Crenshaw coined the term intersectionality to describe a method of analysis that reveals the dynamics of subjection hidden by what she called single access analysis, and to suggest avenues for intervention and resistance that are eclipsed by single access approaches. Crenshaw demonstrated that projects aimed at conceptualizing and remedying racial or gender subordination through a single vector end up implicitly positing the subject of that subordination as universally male, in the case of single axis anti-racist analysis, or as universally white, in the case of single axis feminist analysis. So this idea of intersectionality is really about different axes on which people experience life and experience the world, and different lenses through which one could process reality. And intersectionality is also about oppression. So the case of Emma de Gaffney is the case that this theory is built upon. And Kimberly Williams Crenshaw is a lawyer and also an academic. And so Williams Crenshaw discusses this case of Emma de Gaffney as somebody who tried to get a job and found that all of the jobs that were often done by men, which were kind of jobs that were often heavy lifting in that time period. It's a very old case, but in a certain time period, cis-het men or cisgender heterosexual men often did a lot of labor, physical labor. And so all of the jobs that were reserved for men were for people who are Black were done by Black men. And then all of the jobs that were often done by women, which were more clerical work, like standing at the front of a counter or a bar, smiling, being a secretary, greeting people at, say, a restaurant, were done by white women. So Emma de Gaffney then was not someone who was thought to be a person who could do any kind of labor because she was a Black woman. And this is obviously highly discriminatory. And this is why Kimberly Williams Crenshaw uses the term intersectionality, because de Gaffney was able to successfully argue in a US court that she experienced both race and gender discrimination and was therefore being discriminated against not only as a woman and not only as Black, but as a Black woman. So the experiences of women of color, writes Dean Spade, become untellable. And Crenshaw's articulation of intersectionality brought to legal theory a key set of insights from women of color feminism and other critical intellectual traditions about the limits of equality, and added these understandings to the interrogations of the discrimination principle taken up in critical race theory. So Dean Spade is a transgender activist, legal theorist, and professor who has written extensively about radical politics. And Spade draws on Williams Crenshaw to discuss the ways that intersectional resistance often involves resistance to laws and forms of discrimination and police procedures that would discriminate against women of color and against people of color. So I'll play a clip of Dean Spade discussing politics. and the law. And so Dean Spade is a professor at the Seattle University of Law.
What I want for everyone, and I think what my other work is.
So Dean Spade is a freedom scholar, and many of the scholars that we've looked at throughout the class are those who write with an interest in social justice and with a purpose in trying to dismantle systems of oppression and trying to also think philosophically about why legal fairness or ideas of fairness or equality and even forms of belonging or social connection, relationships of say trust or empathy or care do not necessarily work for everyone or break down. We have a whole set of laws in Canada that protect freedom and civil liberties, like the Canadian Charter of Rights and Freedoms. So the Canadian Charter of Rights and Freedoms grants all Canadians equality before the law, security, and civil liberties. And the Canadian Charter of Rights and Freedoms is explicitly a multicultural act that upholds the laws of all Canadians. So why did Cindy Gladue die in a really horrific way? And why is she referred to over 24 times as a quote, native prostitute? And why is the public in many ways, in some ways largely indifferent, except for very small sections of, say, the feminist movements? And these are questions that I think we have to ask. And even this idea of saying white man, like, why is it impossible to use this term white man? And what does it mean? And what power structures are upheld, or what kind of invisible forms of privilege and power are upheld? And if we cannot say that Bradley Barton was a white man, then I think that this means that Cindy Gladue will always be someone who can be reduced to matter. And I think that this is an essential problem for social justice. That people cannot kind of have things both ways. Like if we were to think about it in a logical way, like what social justice as a brand often does is to try to then find these cases of Cindy Gladue and talk about them extensively, and also to celebrate Black women and to celebrate women of color, to celebrate Indigenous Fashion Week, without saying anything negative about whiteness or white people, which then sounds like a language that is combative or even scary. I don't think that you can ever really critique capitalism without critiquing the richest people, those who Marx would say are the ruling class. To try to kind of celebrate the working class without having a sense of animosity towards the richest people, who in many ways in Canada are still white settlers, is not really going to do anything. And if someone has read Marx, they will understand that Marxism is not really a philosophy that argues that the ruling class will never have to pay for their crimes. Like someone would actually have to be held accountable. Bradley Barton would actually have to be a white man who is not celebrated as a white man, with a whole set of privileges that are never named. So these are my thoughts. Intersectional resistance for Dean Spade involve practices aimed at dismantling population control. Intersectional resistance practices aimed at dismantling population control take as their targets systems of legal and administrative governance, such as criminal punishment, immigration enforcement, environmental regulation, child welfare, and public benefits. We can approach gender, sexuality, and the law by looking at how certain forms of colonial knowledge are embedded in criminal justice systems and systems of law. So this kind of colonial knowledge then is really about epistemic violence and what Gayatri Chakraborty-Spivak would term epistemic violence. Epistemology is the study of knowledge. It is how we know things. And how do we know that Cindy Gladue can be named and Bradley Barton cannot be named? And I would argue that this is about colonial knowledge, that you cannot name the knowers as knowers. They must be named as those who speak the truth. So if I'm the only person that can produce knowledge and write things down, if this language, the English language, is the only language, then it is just language itself. It is not English. If the only kind of law that exists is modern European Western law, and there's no, say, religious law or traditional law, then I just speak the truth. Like, one set of ideas is the only ideas. I guess this leads us back to the criminal justice system. If capitalism is the only system that exists, then anyone who kind of critiques capitalism is not really seen, is often not taken seriously in this time period. And those who cannot exist within capitalism are obviously criminalized. So knowledge production is really about power, and who has the power to be seen to be just telling the truth and not speaking from a certain very privileged position. So Cindy Gladue, and the case of Cindy Gladue then garnered a lot of protest and support from many people throughout Canada and throughout the United States of America as well. And the protests that followed Bradley Barton's acquittal were extensive. And I think the case of Cindy Gladue remains one of the most reported cases by the Canadian media and by the global media. And there was a great deal of controversy surrounding Cindy Gladue's trial as well. So the details of the trial are quite graphic, and I should give a trigger warning that in reading the details of the of the trial and Cindy's death, the descriptions will be quite graphic. So if you find this graphic content to be upsetting, and hearing about the circumstances of Cindy's death, you're welcome to log out, of course, and you can look at some of the articles as or other articles from next week's, which will be in March. We will discuss the book that I wrote about art and artists in detail, and we will talk about artists. And so it will not involve this kind of really brutal realism. So the controversy was actually about the use of Cindy Gladue's vaginal tissue as evidence in the courtroom to further analyze the wounds that Bradley Barton is accused of inflicting against the victim. So this use of Cindy Gladue's actual body parts, which were kind of photographed and displayed on screen after she died, was considered to be extremely controversial, as many believed it was disrespectful to the deceased and contributed to dehumanizing her. This was the first use and acceptance of tissue from a human body as evidence in a Canadian courtroom. Moreover, some argued that racial prejudices and discrimination against sex workers was apparent in the courtroom, with one source saying that the words native and prostitute were used repeatedly, and another source saying they were used more than 50 times. Mhm. So I'll find a clip about the Cindy Gladue case. The protests were extensive, and especially the controversy surrounding the trial, I think, and the use of really graphic images of the deceased body. Was one of the many traumatic aspects of this case, like the kind of re-traumatizing of victims, even after they die, and the re-traumatizing of the victim's entire family was widely debated in this case, as it has been in many cases of missing and murdered Indigenous women and girls.
Of family.
For some reason, this is not okay. I think. Sorry about this. It's a really shocking case. It's quite sad. And she was only in her 30s when she died, Cindy Gladue.
The end of a 10-year journey, her thoughts surround one loved one. Cindy. Cindy's mother, Donna, in the glow of affection, granddaughters, great shares the late On this night, the jury began deliberating on the fateful demand charged to take June 22nd, 2011. For the past decade, they've been waiting for justice. Prairie of Dowie, the Cindy. Cindy, the oldest of four, grew up with her family in Northeast Edmonton. Nicknamed Shandy by her grandmother, she loved cuddling with her daughter, watching photo shows, making breakfast with her mother. To her family, Cindy was Spark. She was She taught that spark to her children, three daughters, Cheyenne, Brianna, Brandy. Her daughters now have children of their own, grandchildren Cindy could never meet. The devastation continued for the family when the trial began. The brutality of her death dissected and repeated. Words, constant references to sexual images of her body, bloody bath. The first trial reduced Cindy to a stereotype. The Crown and defense referred to her time and time again as Native American. In 2015, the man accused of killing her was acquitted. The decision sparked out protests across major Canadian cities. The case was appealed all the way to the Supreme Court, which ordered a new manslaughter trial in 2019.
She was objectified and dehumanized as a specimen.
Family, 10 years of headlines, reduced and obscured the fullness of Cindy's life. And her family's now fighting. Early Friday morning, Cindy's family makes that familiar walk back to the court to await the verdict. 9 hours later, bittersweet relief. Bradley Barton, guilty of manslaughter.
She's a daughter, she's a mom, grandmother. Everybody's happy.
This is only the beginning. Again, and maybe now, 10 years later, Donna, Cindy, it's news.
Family members of Cindy Gladue, a Métis and Cree woman who was killed in a hotel room, say the pain they continue to feel a decade after her death is unspeakable. Cindy Gladue's mother, cousins, and sister told a sentencing hearing for Ontario truck driver Bradley Barton that they relive her violent death every day. I feel broken when I see my great-grandchildren with their mothers. Without my daughter and without their grandmother, Donna McLeod said in a statement read in court Monday by a representative of family. I've spent every day for the last 10 years reliving the violent death of my daughter. I've become a hypervigilant grandmother who is constantly having to know where my kids and grandchildren are at all times. A jury convicted Barton, 53, of manslaughter in February. Gladue, 36, died in his room in Edmonton's Yellowhead Inn in June 2011. It was the second trial for Barton. A jury found him not guilty in 2015 of the first-degree murder, which sparked rallies and calls for justice for Indigenous women. So during the first trial, the judge and lawyers referred to Cindy as a prostitute or sex worker over 50 times. She was not referred to as a human being or honored as a mother, daughter, or friend of the many that mourn her passing. This disgusted Indigenous and women's rights leaders. Thousands of people showed up in protests across the country to condemn this treatment of Cindy. So in the public discourse of missing and murdered Indigenous women, ugliness, writes Catherine Morton, has acted as an essential descriptor. And obviously, ugliness as an idea is not about like modern ideas of beauty or like consumer-driven ideas of beauty would be, I guess, attractiveness. What Morton means is that the bodies of Indigenous people are often depicted as addicts, and there is this kind of wasting of the body that is shown in their photos. So Indigenous people are often shown with bottles of alcohol or cigarettes or drugs. And so this kind of depiction of the Indigenous body as one who is an addict then again comes to justify crime. That if you constantly depict people as criminals, then if they are victims of crime, will you believe them to be victims of crime? And the answer, I think, historically throughout the history of the criminal justice system everywhere in the world has been no. So from a feminist perspective, women were often depicted as people who were provocative or not innocent enough. And women have often been defamed for not being morally innocent or have been depicted as not being chaste. Depictions of women's dress or use of cosmetics or smiling at people on the street have often been used to defame the character of women. So when women are victims of sexual assault or sexual harassment, can they be believed? The answer is obviously yes. However, media and lawyers and judges have consistently used laws against women, and media and judges and lawyers have consistently violated the law to suggest that women are not victims of crimes like sexual assault and rape. So the idea of provocation has been central. It's been central to debates in the court system and within the feminist movement. And trying to vilify a group of people is one way that you can consistently commit crimes against them. So negative depictions of women in the media, overly sexualized depictions specifically of working class women and young women allow for crimes of sexual assault and rape to go unreported or underreported. They also allow for police to not register cases of rape. So in certain states in the US, feminist legal scholars have done extensive research about the refusal to record or write down rape as a crime, irrespective of the experiences of victims, that many police will not register cases. So this depiction of Indigenous people as addicts allows the violence of these cases to become inevitable and naturalized. More sinister still, writes Morton, ugliness diminishes or at least neutralizes violence, both chronic and acute, faced by Indigenous women. What value is there in naming a missing Indigenous woman as a drug-addicted sex worker, other than to construct her victimhood as not only ugly and shocking, but unavoidable? Ugliness is deployed in order to bolster the us versus them, colonizer versus colonized, civilized versus savage binaries that are inherent to the ongoing colonial project. Naming missing and murdered Indigenous women as ugly bodies makes it possible for these ugly victims to act as the perfect foil to civilized, innocent, and attractive white feminine colonial bodies. Ugliness allows for the maintenance of colonial power and equality by unequivocally naming Indigenous women as lesser than. What would it mean to move past a politics of ugliness in regard to the issue of missing and murdered Indigenous women? What would it mean to radically reconfigure the public discourse? And therefore ask how these bodies can disappear. And Morton's chapter in this book called The Politics of Ugliness grapples with these questions and unpacks how the politics of ugliness are interwoven with settler colonial, racist, sexist, classist understandings of Indigenous women's experiences, particularly experiences of violence. So these kind of awful photos. I mean, it kind of is embarrassing in many ways, and I feel embarrassed about all of the depictions of Indigenous people that are so kind of obviously discriminatory. Like if someone dies, you would think that they could choose a photo. Like if I died today, I would hope that someone would choose a photo that was somewhat flattering and would not find a photo of me in some sort of compromised position. Maybe at a low point in my life when I feel very depressed. I mean, many people do drink alcohol. Cigarettes and alcohol are also taxed substances for Canada's economy. But these photos are never ending, that when Indigenous people die, there are often all of these photos that try to show them as being addicts. Which could be true as well. I mean, many people have addiction and mental health issues throughout Canada, throughout the world, but the use of the photo to make us think about addiction and nothing else they did with their life is really about the criminal justice system. When women and girls are raped or sexually assaulted or sexually harassed, the use of the photo after they have bravely told the truth about trauma is really telling. And it really tells us something about the media and the criminal justice system. So dominant perceptions of ugliness, Rex Morton, seep into the messaging around missing and murdered Indigenous women. In Corrigal, Brown, and Wilkes' research on constructions of Indigenous peoples and issues in mainstream media, the consideration of camera angle, photograph content, and poses are taken into account. The ugly victim within the images of the visual discourse loses individual identity and is disempowered. Corrigal, Brown, and Wilkes find camera angles in the colonial gaze, rendering the Indigenous person being photographed and their relative size to be important visual cues that establish the power or powerlessness being communicated through the image. These very subtle decisions in composition are important cues that establish the trope of the ugly victim. These composition choices, although subtle, cultivate a sense of wretchedness that is critical in the perception of ugliness. Dependency and helplessness are immediately recognizable as ugly or undesirable behaviors. By utilizing the composition of the images to indicate the subordinate position of the ugly victim, images become silent affirmations of the existing power relation. Indigenous victims as the helpless and vulnerable wards of the state. So this idea of the production of beauty in Canada as opposed to ugliness is really about class, race, gender, and settler colonialism. So all of the media production you can see on Facebook and Instagram of middle-aged, white, cis-het suburban families and their perfect teeth and their perfect children and their cottages and their condos and their suburban homes and their SUVs and their large, expansive kind of presence in the world is about a production of settler beauty that corresponds with these images of Cindy Gladue, who is in a hotel room. She's not in a suburban home and who is depicted alone and as an addict.